The model tenancy laws have been greenlit by the cabinet and are intended to put a fixed template in place for states and union territories to follow when it comes to contracts between landlords or landowners and tenants. Some interesting salient features of this is that it caps the amount of deposit that can be taken to 2 months for residential premises and 6 months for commercial premises. It lists out, among other things, what the landowner needs to do, what their responsibilities are, and what the tenants' responsibilities are. Some of the useful things that come in this is the landlord, for example, is responsible for maintenance of the premises, whitewashing of the walls and the permanent fixtures. The tenant is responsible for things like switches, sockets, window panes, and things that could bear wear and tear because of them being there. I think some of the most salient parts of this model tenancy law also is that it gives a lot of protection to landowners. Remember, it's with prospective effect. So all of those millions of cases under dispute don't get affected by this. And there's a long legacy of that in India, of disputes between landlords and tenants who perhaps sometimes refuse to move. But this will clear the slate for prospective tenancy agreements. So in this, for example, if a tenant refuses to move out after a lapse of the agreement for 6 months, it will be deemed that that agreement continues at the same rate. So the tenant has to keep paying. Even after that, if they refuse to move out, they have to pay double the rent for 2 months. And after that, 4 times the original rent for the next 4 months. So a slew of measures that have been announced in a bid to protect both the tenant and the landlord. The aim is to give a fillip to real estate going forward. In fact, ET now caught up with Hardeep Puri, Union Minister, to speak about the proposed rules, and here's what he had to say.
I would hardly describe myself as the chief architect of this model Tenancy Act. I think the idea of a model Tenancy Act has been around for a long time, and I am a relative newcomer to the scene. I only joined the Council of Ministers in September of 2017, and this idea was very much around. Let me tell you, there was a GOM form, I think sometime in 2019. But even before that, when my friend Arun Jaitley was the finance minister, I recall attending meetings in his room, which had representatives of the state governments, etc. So it's been going around for a long time. The real necessity of this Model Tenancy Act, and you're absolutely right in describing this as a model act, because land is a state subject. If we were to enact legislation at the central government, I mean, the states would say, you are intruding onto our turf. So it's a model act, and the purpose is to provide a regulatory framework which is benign and which results in the large stock of empty units, both residential and commercial, in urban areas as well as rural areas, for them to become available. How will they become available? Because landlords will hopefully, with this new dispensation coming into being, they will have the confidence to be able to allow their properties to be rented out based on modern contractual conditions, which the states will provide through either their existing legislation or by enacting new legislation, and on terms and conditions to be agreed to between the buyer and the seller of the service, which is a tenant who is getting their premises for a defined period of time on terms and conditions which the landlord will provide. So it's a...
All right, Anshuman Magazine of CBRE and Gulam of Knight Frank on the show to explain what this really means. Welcome to both of you. Anshuman, let's begin with you and your take. Will this really make a difference, considering several states have their own robust laws in place? This being successful means the states will have to accept these and replace their own laws with this. Do you think that's going to happen?
Well, I'm not sure if the states will take it up easily, but certainly if this is implemented, it will have some impact. The good part is over the years, legally in the commercial space, it's not a big issue because normally you sign a lease, it gets registered in the court. So in generally speaking, largely in commercial leasing, this is not going to make any much difference. In residential, however, it will have some positive impact, because there are, like the minister was mentioning, that there are a lot of people who buy a second home or as an investor. There are a lot of apartments in Gurgaon or in Bombay or in Bangalore, Chennai, wherever, which are lying vacant. And there is a little bit of hesitation from owners that if they were to rent out their space, they may not get it back. But I must say, over the years, that has improved. If I go back 20 years or 15 years back even, it was sometimes very difficult to rent, especially residential space, and then get the tenant out. It had improved. So this act will certainly be, it'll make a difference. It'll make a difference. Primarily difference would be giving confidence to the owners to rent their space out, and hopefully it'll improve supply of rented properties going forward. Only thing is, I don't like putting limitations. For example, it talks about the deposit to be limited. These things should be left to the market forces. However, overall, the concept is good, and if implemented in the residential space of the supply of rented properties is expected to increase.
Gulam, do you see it that way as well, that this will truly give a fillip? Because the claims are that this model tenancy law will give a fillip to more tenancy rights, will lead to a better utilization of properties. Do you see all of that happening?
Well, I'm sure it will be an impact. It will have an impact on the scenario, on the overall scenario. Taking it up from Anshuman, he spoke about this very, very clearly about the difference between commercial and residential. And I would love to put a few numbers. You know, in as far as commercial space are concerned, almost as much as 90-95% space, A-grade space all over the country are on rental basis. If you turn it around to residential, it is actually the other way around. It would not be more than 15 to 16% of residential stock which would be on rental concepts. And that has to change. That has to change because many of our large section of our population is actually migrating to various cities, etc. And they are not in a position to buy the stock, buy the home for themselves. And that is why whatever act they're talking about will give some respite. As Anshuman Magazine mentioned that over a period of time it has changed. It has changed for sure. I know of, I have come across cases where such matters have been resolved in the court of law in Mumbai in a matter of a year or so. And that is a big respite. You know, if you look at the old days, we used to hear about cases dragging in the courts for decades or generations. But that has changed drastically. A leave-in license agreement disputes can be resolved fast. So what we are looking at is a good mechanism, but it has to be given a lot of teeth, you know, because otherwise, well, there would be some time to see the effect of it. Like we would talk about real estate regulator, the RERA. It is still work in progress. It has still not given the kind of desired impact that it was given out with. So it is going to take time. As the minister also mentioned that because it's a state subject, various states will have their own priorities, etc. They will put up their own angles to this contract, the model act, etc. But over a period of time, the efficacy of it will completely depend on how seriously states are managing it. You know, because every state has its own share of migratory population. Depending upon how are they going to give the solution to the housing of the migrating population, each of these states will have to give it the kind of impact that they desire. But whatever said and done, it's the right step in that direction. Maybe late, whatever it is, but I'm very positive that it will have an impact on the state of affairs.
What in your view, Anshuman, will be the big major impact? Is it the defining of the nitty-gritties? For example, the number of months of deposit which need to be taken. For example, what the responsibilities of the land owner are, or the responsibility of the tenants are. What happens if they don't vacate? Do you think all of these in a template will really clarify the situation and help, avoid future conflict?
I think there's only one. Of course, deposits all is important, but not that significant. There's only one big impact of this, which is the owner of a residential property will have more confidence to rent it out. Forget about all the detailing. And if it gives them more, like Gulam mentioned earlier, that the percentage of owners of residential properties leasing them out is very small. And that is one of the reasons, the constraint also, because anybody, like you mentioned, people migrating or someone, young person who wants to rent out a residential property, it's not easily available to them. This will, and part of the reason is, for example, a owner may say, look, this person's a young person, he's single. If I give him a property, he may not vacate, or he may not have a dispute resolution, which will be quick in case he doesn't get the rent. If this model Tenancy Act gives confidence to the owners, which I think it will, I've not gone through the details, if it is implemented properly, it will give confidence to the owners. It will increase the supply of residential real estate leasing for people who want to rent in the marketplace, which will make life much easier for a lot of people who are starting out in life, or people who are migrating, or people who want to rent and not to buy. Because all those owners, so it's like also sort of making a non-performing asset perform. So a lot of people, because in India, and another interesting thought is coming to our mind is, traditionally what has happened is, most people did not buy, if you're buying a commercial property, you're buying on a yield, thinking of a yield. So you think that if you, in today's time, you buy a rented commercial property, you'll get a 7.5%, 8.5% return. When you're buying a residential property, you're buying for capital appreciation because the yields are very low, 1% or 2%. However, so a lot of times people just lock it up and say, look, I'm not going to get much of the rent anyways. And I'm taking a risk that if I give it to somebody, he may not vacate, and I will go through a lengthy litigation, right? This will allow him to say, look, fine, the yields are low, but because the capital appreciation is not as high as used to be, and maybe the person wants to hold the property for a long period, at least in the interim, he'll get some income, even if it is low, because the owner feels secure that he'll be able to get the property back after the agreement is over. And in case there's a dispute of non-rental payment or whatever, he will have a dispute resolution which will be faster. So he'll at least earn something out of that property, unlike what is happening. So the landlord earns some money, even if it's low, and people have opportunities, will have more opportunities to rent properties. And hopefully with the supply, the rentals will remain competitive. And this is also more true in Mumbai, where compared to other cities, the rent, more people, I think, rent traditionally because of migration, and the rentals are high. So if supply increases, I'm hoping the end result should also be that more people should get access to rental housing at a lower cost.
Tell me, Gulam, does this help with all of the pending disputes? I know these rules are envisioned as being prospective, not retrospective, but does it then make a case for resolution for the thousands and thousands of cases that are stuck up?
Not really. As you yourself explained, that if it does not have a retrospective effect, then it will not really have much of an impact on the cases which are going on. And the cases which are going on are, as you rightly said, have piled up, and especially because the archaic rent control acts that most of the states, including Mumbai, in fact, the major problem, the bone of contention, the biggest hurdle for the growth of the city is Rent Control Act. So that is exactly the problem. Under the old Rent Control Act, there are lots and lots of these cases which are pending. And at least I don't see it easing out even after whatever we are now talking about. In fact, taking it up from Anshuman, he spoke about litigation, and I gave a brief example of the comfort that the landlord gets when he or she knows that the resolution will be quicker. So if I am confident of a resolution within a year in a city like Mumbai, I as a landlord would be happy to actually rent out my premises. So that's half the battle won the moment we are getting the confidence of the landlord to rent the property. and which is what your question was also about. Going forward, for sure, I'm confident that the kind of environment that is getting created under this new act will give most of the landowners or the apartment owners enough of confidence to go ahead and start renting the property, even if the yields are low. As once again Anshuman Magazine mentioned, 2%, 3% of a yield is not really an incentive enough for a landlord to put the property, especially looking at the risks. So if the litigation risks are sorted out, the only thing that remains is the market parameter, which is what kind of investment returns am I getting? And for which, as earlier once again Anshuman mentioned, that the 2% or 2 months or 3 months of rental that they are putting up would actually be a negative, because it will have an impact on your free market expectation of rental yields. So that is something which will actually be, I would say, a spanner in the whole thing. The landlord will not be very happy to see their rents or the yields going down because the advance or the deposits are actually shrunk, or there is a ceiling on that. So here it is, we have actually won half the battle. Two parts to it. One is the litigation support, which we are creating the right environment about. Now comes giving a reason, the financial reason or investment return to a owner to put up this property out in the market. As we're talking about, yields, like for example, in markets like Dubai, are 6% and more, which is very lucrative even compared to a commercial property. So here, the remaining battle that needs to be won is on the commercial grounds now. How do we ensure, and it does not mean that we need to raise the rents, we have to create the right environment to perhaps give incentives and motivations for people. Perhaps you give them, you make capital available for them to buy such properties if it is only for the rental purposes and so on. So a lot of those motivations and incentives now have to be worked out to now win the remaining battle, which is to make this whole asset class, the residential, as a more profitable one.
So, Anshuman, what are your concerns as far as commercial contracts are, as far as commercial contracts go? What would you like to see ironed out there? And do you think there's enough in these model tenancy rules and propositions to ease up commercial transactions and rentals?
Like I mentioned earlier, the commercial transactions is not a big concern because generally speaking, these are a lot of the space are taken by multinationals or Indian corporates who would go through a proper lease agreement. In most cases, largely they will register the lease agreement. And once you do that, and like Gulam mentioned earlier, the whole litigation process, of course, our courts are still very slow, but generally speaking, it has the whole dispute resolution mechanism has improved over the years, actually quite significantly. And more or less, any owner of commercial property would not be too concerned, like an owner of a residential property, that if he or she were to give their office property for rental, that they will have any issues. But they just have to make sure that they sign a proper document and get it registered. They're generally safe. I'm just hoping that if this is implemented properly, that even that dispute resolution today in commercial, if it takes 1 year or 2 years, now we think that is because we are used to 20 years, we think 1 year is very efficient or 2 years is very efficient. But the fact is, if this can bring it down to, let's say, 3 months, that itself will be a big plus for the commercial owners. I have not read the fine print yet. I just hope that they have not put restrictions on deposits, etc., even in commercial properties, because like Gulam was mentioning earlier, this is that has not only an impact on what yields are getting, it's just the entire structure when you're giving out.
It's 6 months.
Yes, so yeah, but
yeah,
I still
it's 6 months so far.
Yeah, so that's not right, because it should be left, and especially what has happened now is that unlike in the past, where the commercial space was owned by individuals, now there are institutions who own it, and a lot of it is larger institutions, like you would say Blackstone, Brookfield of these world. Plus there is REIT structures where they are owned through a REIT structure. So, and where there are, you're just putting one deterrent unnecessarily in a market when some institutional investors owning it, or even an individual to invest when there's a restriction on deposit. Because what it could do is, in some ways, it can increase the rental in case you put a restriction on deposits, because it's a whole package. So if your deposit is higher, rental is lower, because all calculations done. So I think that should not have been done. We should be far away in this day and age for putting commercial restrictions on any kind of business, because if it should be left to the market forces, and the market forces decide. If the market is really down, maybe the owner may just charge 3 months security deposit or 1 month security deposit. So why? And it could be vice versa. But end of the day, the market forces determine what should be the rental and what should be deposit. So I don't think that's a good move. But overall, if it gives more confidence to people, like I said, I'm not too worried about the commercial, except that in this case, this restriction in commercial is actually negative. And mostly, largely for commercial space, you don't need.
I think it's an upper limit. It's possibly, yes. It's possibly an upper limit. It's possibly an upper limit at this point. And
but even upper limit,
the big challenge really is how.
Sorry,
Yeah.
I'm just saying upper limit, in office leases, deposits can be 12 months, 24 months. And it is not just because I think what they have done is they're equating residential to commercial. In a commercial space, it will be a corporate occupying it. I can understand residentially trying to protect an individual and feel that, although I feel there should not be restriction there, but you're trying to think, I'm sure, that let's protect the individual who's taking the housing and keep the deposit low. But in commercial, largely it will be an organization taking it, and they can negotiate it where, like I mentioned, the deposit will be 12 months, and sometimes they may prefer giving 12 months deposit and giving a lower rental. So I still believe that there should not be any limits there. Residential, of course, I mean, in a way you're protecting the consumer, but then there is still interference in the market mechanism, which at least I personally strongly believe in, because end of the day, it's the market should determine all this.
The big challenge that may come up, Gulam, and tell me what your view is, but the tough part that I can see prima facie is setting up all of these new tribunals to be the last port of dispute if there is a dispute between the two parties. Will the infrastructure of that exist, and how easy or difficult would it be to set that up? Let's take a look at what the places are that people can go to right now for disputes and how well they are working.
Yes, as I spoke about earlier, Tamanna, I am privy to, I have seen it personally. There's a separate infrastructure, at least in Mumbai, that exists for leave-in license agreements to be disputes to be heard separately. And that is a good mechanism, because you don't have to go through the normal city and civil courts or et cetera, et cetera. There's a separate court altogether. At least in the state of Maharashtra, it exists. I want to believe that the other states would also be, if they haven't already put it up, they would be doing so. And that mechanism is something which will give much comfort to every landlord to really do this, the next step of letting the property. And here comes the next aspect, because whatever experience I have is that while it has taken about a year to get the resolution, but then to get the police to help implement that resolution also may take time. What I mean is that while, like we have been watching it even in the case of regulator Darera, that the resolutions or decisions are coming, but then you can take it to high court and et cetera, et cetera. But in the interim, in case of rental property, the landlord will suffer hugely. So while on the other side, and especially for residential where there are small investors like you and I who would want to give one apartment on rent, we may not have wherewithal to approach the best of the legal support, etc. And that is where it becomes a lengthy procedure. So not just a proper litigation and dispute resolution mechanism which is called for, but also the force to help it implement, because I have seen it, even after the decision is there, the police would take 2-3 months or so to actually give the force to forcibly vacate the property, etc. So it is a tricky procedure as far as residential is concerned. And your question is what more should be done? Well, under this act, at least I would want to see all these hindrances removed. I would want to see this whole thing lubricated so well that the whole litigation thing at least is put to rest. Even if later on we can debate, argue, and look at the commercial side of it, as Anshuman was talking about, on ceiling on rents or making it more lucrative. That is a separate war, I would say, we need to fight. But at least the litigation side, if we have taken care of, it will help immensely to put the properties in the market. And just one last small point to support what Anshuman was talking about, especially in commercial properties. This is going to be a huge deterrent also, because many of those commercial deals are actually made to order. There are tenants who are asking for such kind of spaces. These are pre-lit properties which are created or constructed for them. And you can't take such a big risk. It takes at least 2 to 3 years to construct that property. So for the sake of 2 or 3 months of a rent, you can't put such a huge capital behind constructing this whole property. What happens after say 2 years, when the tenant says that I don't want the property, what you have is barely 2 to 3 months or 4 months of deposit, which is peanuts. So here is where the market forces are deciding what has got to be the deposit, which also needs to be taken care of. But I say, your question to me was litigation side of it. It is looking good. It needs to be now implemented to ensure that litigation side is taken care of. Commercial, we can keep discussing later.
Absolutely. Thank you so much, Gulam and Anshuman, for joining us today and taking us through the model tenancy laws. It's something which has been in the works for a while. We'll have to wait and see how states implement it and how smoothly it goes forward to make life easier for both the landowner and the tenant.